Thank you and welcome to the National Judicial Network Forum on Human Trafficking and Immigration Issues in State Courts. Today's forum will focus on the state court's role in protecting and safeguarding vulnerable immigrant youth. And in that regard, we will talk about the correct judicial determinations that need to be made by state court judges for special immigrant juvenile status. And we will also focus on other forms of immigration relief that judicial officers need to be making at the same time for the best interest of youth, immigrant youth, and their families. My name is Susan Briel. I'm a judge in the San Francisco Superior Court, and I handle dependency cases. I also handle all U visa certification requests for the civil division of our court. Leslie?
Hi, good afternoon, everyone. I'm Leslie Orloff. I direct NUAP at American University Washington College of Law, and I'd like to welcome you all to this webinar. I just want to, as we get started, so I'm an adjunct professor at American at University Law School, and I've been involved in creating immigration relief benefits access, and I also do a lot of family law issues. So this intersection of family law and immigration is kind of one of my sweet spots. As the kind of host here today, I want to let everyone know that the slides will be available for you. We will send you an email with a link to a web page where you can view the slides after the training. We're encouraging you, if you have questions during the presentation, to put them in the chat. We don't have the Q&A function available, and we will try to get to those questions as we go forward with the presentation. If there are any that we don't get to, we'll communicate with you afterwards to make sure we get all your questions answered.
Good afternoon. My name is Veronica Stronson, and I'm a visiting professor at the University of Minnesota Law School.
I'm David Thronson. I'm a professor at Michigan State University, and I filed my first special immigrant juvenile case in 1995. So we've been doing this a while and have seen it ebb and flow, and I'm happy to be here to talk with people about this.
So as we get started, I want to thank the State Justice Institute for their support of this webinar. However, the opinions, conclusions, recommendations, everything you hear today is going to be the opinions of our presenters, Professor Veronica Thronson, Professor David Thronson, Judge Briel, and myself, Leslie Orloff.
So before we begin, I want to encourage everyone who is participating today to join the National Judicial Network. We have 543 judges in 44 states participating, and this is a great place for us judges to get continuing education credits, to have peer-to-peer conferences, to get great bench cards and technical support, and get the latest information on immigration issues, to meet fellow judges around the country, and to have confidential support if we have some pressing questions. If you're not a judge, you're a lawyer or an advocate on this forum, I would really recommend that you encourage the judges you appear in front of to join the National Judicial Network. They will thank you profusely once you explain to them this amazing network and learning forum. So our learning objectives for today are to recognize facts that indicate a child qualifies for special immigrant juvenile status, or SIJS, and fulfill the role Congress has given to us state court judges to issue judicial determinations in a child's best interest, promote early identification and referrals of children and caregivers eligible for SIJS, VAWA self-petitions, UNT visas to lawyers with expertise on these victim-based forms of immigration relief, understand the benefits of filing for SIJS together with U visas, T visas, VAWA self-petition applications to maximize long-term stability and protection for a vulnerable youth and their family, and to be able to issue or obtain judicial U and T visa certifications when presented. So we're going to do a poll to see who is attending this webinar. And if you could just let us know, are you a judge, magistrate, commissioner, court staff, counsel, child's counsel, parents counsel, a CASA, family law attorney, victim advocate, or other?
And if you're other, you could please type it in the chat. That would be great. I think we don't have other as an option. Okay, I'm going to end the poll, give you a couple more seconds. I'm going to share the results. So we have a few judges. We have a good amount of court staff, child's counsel, CASAs, and a lot of victim advocates and family lawyers.
Great. Our next poll is, have you ever either issued an SIJS judicial determination, denied a request for SIJS judicial determination, requested a special immigrant juvenile status judicial determination from a judge, or none of the above?
You guys are great. The responses are coming in fast and furiously. Excellent. I'm going to give it a few more seconds.
Yes, this is fantastic.
Okay, I'm going to share the results. So what we're seeing is 3% of you have issued them, 24% of you have requested them, and for 74%, you haven't done any of that. So you're more new to this. So we're very excited to kind of hopefully build your skills so you'll feel comfortable understanding how important this is and being able to request and or issue orders in SIJS cases.
I love it when new people don't know what this is and want to learn. So special immigrant juvenile status is something created by Congress. And let me just get rid of the poll here. And it's a classification to provide immigration relief for certain undocumented children who are in either foster care, guardianship, or adoption situations. And the state court really has a role to play in a child being able to get special immigrant juvenile status. A youth seeking lawful immigration status will be able to do so when the judge is involved and makes certain findings. Immigration laws, of course, are complex, but Congress has created the ability for judges in their role to make certain judicial determinations that will help a youth gain immigration status through SIJS or special immigrant juvenile status, whether they're abused, abandoned, or neglected, or crime victims. There is a role for us state judges to provide certain findings to allow youth to then apply for this status.
Oh,
Both push the button, sorry.
go back to we're both pushing buttons. So this is a chart that's more confusing probably than helpful at this point, but just want to give you a big sense of what we're thinking about, how cases might flow through our system and young people coming before the juvenile courts, the family courts in different ways. And for our purposes, you'll be able to look at this when you get the slideshow later, but you see that there are different courts and different decision makers involved in this process. The state court is critical. It's a baseline of where a lot of the determinations about the child's situation take place, but the immigration court may be involved if the child is in removal proceedings, if the government has served them with a notice to appear and is seeking to remove or deport them from the United States. Some of the adjudication of the immigration benefits is going to be done by USCIS. And only, even if a case is in immigration court, certain things will only be decided by USCIS. So part of what we're going to see as we walk through this in detail is what gets done in what form. Where does this happen? What are the different postures in which kids come before you? Children might come before you in the state court system in a variety of postures. They might be in removal proceedings. They might have been picked up by Border Patrol and placed in Office of Refugee Resettlement custody and moved through into what we refer to as a federal foster care system as they go forward. Or they might have never had any interaction with immigration enforcement or officials at all. They might be a child who ended up in, due to abuse or neglect in a domestic foster care system, and they could be just appearing before you. They could be, we'll see, someone coming in and saying, we're seeking a guardianship. So there's lots of different postures here. And so big picture to think about is figuring out what's your role in the state courts as a judge or an advocate. What are you going to go do there? And then thinking about what are things that the immigration system is going to take care of and decide what's advocacy and decisions that will be made elsewhere, and how do these things relate and how do they feed in together.
So there are three basic SIJS requirements. A child has to be a dependent of a juvenile court, dependency, delinquency, probate, family court. Reunification with one or both parents is not viable due to abuse, abandonment, neglect, or a similar basis under state law. And it's not in the child's best interest but to be returned to his or her country of origin. And those are the three basic requirements.
From those, we're going to look and say, as the government has moved to implement this, we've, through regulations and also through the statute, got some other sort of more basic types of things. Child can be under 21 and still apply for special immigrant juvenile status. That's different than our typical systems where we think of childhood ending at age 18. So we'll talk as we move through each of these, we'll go into detail with them. They must be unmarried. Immigration law has someone ceasing to be a child once they get married. They must be physically present in the United States through the time of a final adjudication by USCIS of their petition. We need this valid court order from a juvenile court, and we will certainly walk through what a juvenile court is, that makes these decisions, these determinations that Judge Briel just talked about, dependency and placement in best interests. And then DHS maintains a role in which they can consent to certain aspects of this moving forward and sign off on this. So from that, we have a sense that what's happening in the state court part of this is that we are making some determinations. We used to say findings, we now say determinations because the statute changed slightly and the regs have changed slightly. But a lot of our case law and older things will say finding. We're going to make these in family court and juvenile court, and then they're going to feed into a process in the immigration system that then takes on a life of its own. So we have here a sense of where some of the regulations are. I don't need to walk you through these. These will be there in the slides to think about what's our terminology that we're using. We have some protections in the system to go forward, but for our purposes today, we're going to really focus in on those requirements that Judge Briel gave us, those three determinations that we're going to be making. As we go. So first, these are determinations made by a juvenile court. And it does not matter what the actual name of your court is. In a lot of systems, juvenile proceedings tend to be delinquency proceedings, but a juvenile court for our purposes today is any court in the United States that has jurisdiction under state law, not federal, state law to make judicial determinations about the dependency and custody and care of children, right? If your court, if the forum you're in as an advocate or as a judge can decide where's this kid going to sleep tonight, who's going to provide for this child, who's going to take care and provide, custody, make decisions with and for this child, you're a juvenile court, whether or not that's your formal name or not. You could be, doing this in all kinds of different named proceedings, but we're going to lump you together and talk about all these different things as a juvenile court. Juveniles.
David, there's a question. Does a termination of parental rights have to happen before somebody can issue an SIJ finding, or is state custody sufficient?
You don't need either of those things for this to happen. So when you absolutely do not need termination of parental rights, we'll talk through this determination later in a little bit about whether or not reunification is viable and what that means and what the timelines for that are as we look through it. So we absolutely do not need to terminate parental rights either at the beginning or the end of these proceedings. It doesn't have to be an element of the proceedings at all. And the child, we'll see, doesn't need to be in formal state custody. We don't have to take a child and say we've removed them from the home. They could be in all kinds of different settings, in guardianships. They could be living with one of the parents, actually, because some of the findings are going to be about one parent, not necessarily about both parents. So we need a court that legitimately is making some decision about the care and custody of a child. And that could be a decision to ratify and say, this child should go home with mom tonight. This child should be in this guardianship. This child may be placed in a formal foster care system. We may terminate rights, we may not, but none of that needs to happen. All we're going to need is that a court is stepping in and intervening in a way under state law that lets them make decisions about care and custody. Now, for most jurisdictions, that tends to be proceedings that have started under state law, which often means before the child turns 18. But we can proceed on the immigration front until 21. And as long as certain parts of that process are finished before 21, some cases may extend well beyond that. So well beyond the state court jurisdiction that's going to be needed and happening there. Other states have extended, in particular for immigrants, their jurisdiction between ages of 18 and 21, so that cases can even be initiated in state courts past the days on which a child turns 18. Other children will get into the system before 18, but if they meet certain criteria under state law, they can remain. If they're still dependent, if they're enrolled in school, if they're under certain settings, that extension might extend to 19 to 20 to other ages based on that. We have here, and when you get your slides, you can look at this, a state-by-state database. So you can look up your state, you can look up other states that folks are in. NUAP has this, database that is current as of April 2026, and they periodically update it to look and sort of say, what are your deadlines for getting this to happen? But a rule of thumb is, unless you know that your state permits something to be initiated in state court later, you want to at least initiate that state court process before 18 as we're getting through there. So the process of getting special immigrant juvenile status through USCIS and all the bureaucracy on the federal end might extend past the jurisdiction of the juvenile court, but we generally want the juvenile court to establish the eligibility of the child and to have jurisdiction over some live matter in the court on the date that they file, the child then files with USCIS. Because what they're going to do first is get some determinations from the juvenile court, from the state court, and then with those in hand, they can go and file for special immigrant juvenile status with the USCIS and with that federal system. But we don't want kids to languish in care that they don't need any more than we would want to, remove a child from a good setting if they're with parents. So a couple things to keep in mind. It used to be the case, and so some people have this in the back of their head, that if you did an adoption and the child was in court to be adopted, adoption ended the state court proceeding, because now the child's no longer dependent on the juvenile court, they're dependent on their new adoptive parent. Under our newer version of the regulations, that does not need to any way be held back or delayed. If a proceeding is appropriately before the court and the court's doing an adoption and makes the determinations that we're going to talk about, and at that point, we move forward. If an adoption happens, that's not going to put the child at risk of losing this status, right? So, and as long as they're subject to the juvenile court jurisdiction at the time we're able to file with USCIS, that's all we need. After that, if the proceeding ends, if the child ages out, that's going to be perfectly okay. So, two-step process, as we've said. We're going to get some determinations. We used to say findings, now we say determinations, pursuant to state law in the state court. That's really, for SIJ, the point at which the state court role ends. At that point, the child, advocates for the child, move forward with USCIS, and an immigration decision is made by the federal government. So one thing to be clear about is you sometimes have concern from a state court judge who says, I'm not an immigration judge. I'm not USCIS. I don't make immigration determinations. I don't make decisions. I can't grant immigration status. All true. And no one's ever in the SSIJ process going to ask you to do that. All you're making is determinations about the child that are relevant to the reason that child's before you in the court. That's part of your normal processing of deciding where this child's going to get care and custody, what's in the child's best interest, and you're going to let those go forward in the immigration proceeding. So some courts have concern about, well, do I have jurisdiction to do this? Because I'm a state court judge. Why am I doing immigration findings? What's happening with my role here? Well, every court at this point, and lots of states that have looked through and struggled with this issue, have said, as part of our inherent authority to make decisions in the best interest of children, to make decisions about custody, part of that, making these determinations, can be a part of helping that happen. You'll see here the citations on this slide are to the restatement of the law. The restatement of the law, Children in the Law, is relatively new, just finalized and just out, and has a section on special immigrant juvenile status. And I'll just point out that this is a restatement of the law. It's not making law. It's not advocating for law. This is a process in which the American Law Institute goes through and says, what is the law? How do we restate it? How do we summarize it? And unequivocally, they've come through and said, black letter law. Right? Think back to your torts class, if lawyers out there, you're always citing black letter law. It is black letter law that state courts have jurisdiction to do this. And every state that's decided it going up through their state Supreme Court or appellate court system has agreed with that.
So we judges make these determinations in particular assignments every day. And these determinations are for the best interest of the child, whether they've been abused, abandoned, or neglected, and what is in their best interest and where they should be placed, regardless of immigration law and immigration issues. We don't provide immigration status, lawful status to these children, but we are mandated as state court judges to make determinations of abuse, abandonment, neglect, whether it's in their best interest of a child to return to their country of origin or be placed in foster care, or with one parent but not the other parent. These are the determinations I make as a state court judge every day. And again, I don't think about what's going to happen in the future with SIJS. I know I'm not providing actual immigration status, but I'm following the law and doing my job in the best interest of a child. It's one piece of evidence that's used for SIJS. A court, and I'm going to read this, can make the determinations in any proceeding related to the care and custody of a child. Relevant proceedings include a child protection proceeding, a child in need of supervision proceeding, a juvenile delinquency proceeding, and others such as guardianship and adoption proceedings. And these findings are made by us judges in state court in these proceedings every single day. Congress recognized that, and that's why this is a first step, as David said, in the process for SIJS status.
So we're now going to take another poll. In what type, given what you've heard today and your experiences, in what types of proceedings are state court judges authorized by federal statute and federal regulations to issue SIJS judicial determinations? And the term in the regulations are judicial determinations. We're talking about determinations here that are made by judges, and that's the current terminology. So, and these are check all that apply. So check based on what you've heard today, check off all the different kinds of cases that you think these SIJS judicial determinations can be made. Let's see about, this one's going a little slower, so please do join us. Give it a few more, I'll give it like another 20 seconds or so. Fill in your answers. I know there's more boxes to check here, so it takes longer. Take a sip of tea while you're doing it. Okay, I'm going to end the poll. About half of you responded, and let's see what we see. So it looks like 81% of you think it can happen in dependency, 60% say delinquency, 75% custody, 36% say divorce, 43% say civil protection orders, and 69% say adoption and termination of parental rights. So, Professor Stronson, what's the right answer? What are the right answers? Are these all correct, or are there any of them that are not correct?
All of the above, right? All of the above. And, keep in mind that based on the facts of any individual case, the judge might not be able to make the requested determinations. But they can look at them, and based on the facts, based on the arguments, based on the law in your state, it's possible that this would happen. In any case, in a delinquency case, a judge is making a decision about where that child's going to go sleep tonight, where they're going to be, who's going to take care of them. Now, it may be that decision has nothing to do with having been abused, neglected. Maybe the child could be returned to a parent, in which case you're not going to get the findings based on the facts. You're not going to get that determination based on the facts. But delinquency is absolutely an appropriate place to make that request and to look and make the argument around those facts, as are divorce orders, as are thinking about a guardianship. You're making decisions about the care and custody of a child. That's all you need in terms of saying, is this an appropriate forum?
And what I
So there's a
want to
question in the
emphasize-
chat about criminal protective orders. What about criminal protective orders for a child not in delinquency, Professor?
So what would happen is, I was just going to go there. We see a lot of overlap. So what's really important about SIJ is to recognize that anytime you have a child who's abused, abandoned, or neglected, or similar basis anywhere in the world, so your typical domestic violence, child abuse intersection, where they're both happening in the same family with the same perpetrator, right? The father of the child is abusing the mother and the child. That could be an SIJ case. That would be potentially an SIJ case where the abuse is happening in your community. And in those cases, it's going to come up that you're going to have an opportunity to make the SIJ findings in the custody, protection order, or divorce case. And that's where they're going to typically arise in those cases. And so it's important to kind of not eliminate those as a possibility. Those are very frequent opportunities for SIJ findings. And so the criminal protection orders, Jacqueline, is a little bit more complicated because the criminal court doesn't have jurisdiction to place the child, but a civil protection order does. So that's the difference. You'd have to look at, it has to be in the context of something where it's not just a criminal stay away. It would have to be where the judge is placing the child.
Yeah, and in addition, a criminal court doesn't meet the definition of a juvenile state court under the regulations. And so since they are not making the determinations about custody and care of the child, that would not qualify as a juvenile court based on the regs.
Okay, and so, exactly. And the other thing is that in the protection order context, for example, these findings could be issued as part of a consent or not protection order. And if there's opposition, it might need to be litigated in that case to get the SIJ findings. You want to try to get them when you're before a court and the court is deciding custody of children. And there's been lots of case law around the country, as David mentioned earlier, as the restatement is codifying per se, that all of these different kinds of courts have jurisdiction and authority to issue the SIJ findings. And these are some of the examples of them. We have materials for you that talk about all of them. And then there is case law, fairly recent case in Vermont, where it says our holding that the Vermont courts have authority to make such findings leads to the corollary principle that courts generally should make these findings when doing so is in the best interest of the child concerned. The ability to do these findings doesn't flow from the federal law. It flows from the court's traditional exercise of its statutory authority with regard to children's best interests. So we have for you a number of resources. These will all be on the web page we send you, where we have collected all of the case law nationally, both in a spreadsheet and in an article, where we have the regulations and the regulatory history. And we have questions from state courts that we got at trainings that highlight the answers to the kind of most common questions that judges were asking at the time, with answers from the regulations, as well as a special immigrant juvenile status bench book. Over to you, Veronica.
The standard of proof for this type of cases is more likely than not, is the preponderance of the evidence. Filing a petition in court for special immigrant juvenile judicial determinations doesn't require a heightened standard. So whatever the state court in which you are appearing follows the preponderance of the evidence, that is what you need if you are filing to try to get these judicial determinations. Another thing, and Leslie covered this a little bit too, is that the judges, we usually train and ask them to include a statement explaining that they have jurisdiction using their state statutes. And we're going to cover this later on, but there is nothing magical or different about special immigrant juvenile. You are the same way you are filing a divorce case or a custody case or any other case that involves custody of the children. That is the jurisdiction that the judges are going to use. And we're going to look at that to see where in their statutes you as an advocate are going to be getting that information to tell the judge that he or she have jurisdiction to make these findings. Another thing that confuses people many times, and maybe it is because in many instances with this type of cases, one or both of the parents are abroad, and people get very confused on how to effect service over the parties who are involved. And basically, you are following the same service rules that you would use to file a custody case, to file a divorce case, right? Like you are going to be following. We have a couple of slides that have more detail on service, and you will be getting these materials. But basically, one of the things that is a little bit different is making sure, if you are the attorney trying to file, making sure that your own state methods are not prohibited in the foreign country if you are going to be serving a parent who is abroad. Another thing too is that many people get confused thinking they have to serve the Attorney General of the state or that they have to serve the government with the petition, and that is not the case. The only thing you need to do is follow your own service rules. Remember, from civil procedure, for those of you who are advocates, you may be even more familiar with how to follow the service rules. We also have in the examples, we're giving you Michigan, showing you what is the process and the manner of service. And if you are still confused and you want to make sure that you are doing it right, feel free to reach out to NEWAP. We provide technical assistance in any of these topics related to service, anything related to special immigrant juvenile, to make sure that you are doing it right. One of the things, though, that I want to bring up is in many instances, maybe the child is going to be aging out and you are not able to find one of the parties you need to serve. So, your rule may require that you serve that person by publication, and that is going to take longer. So as soon as you are doing an intake and you think that this child may qualify, you need to start moving to make sure that everything gets effected before you appear before the judge for your hearing. So that is very important. There are judges, even in Michigan, we have a few judges who ask that in the notice that we provide information on the judge's Zoom information in case people are able to appear by Zoom. So you need to know what your service rules and your notice requirements are in the particular state where you are filing, to make sure that you don't get any delays because you didn't follow the exact procedure that the judge requires in your court room.
If I can just jump in for a second, as I put it in the chat and it's in the slides and we'll have it on the webpage, we've looked up all of the service of process rules and jurisdictional rules in every type of proceeding, in every case where a judge could make judicial determinations for SIJ. So you can look them up. And again, don't think too narrowly, really look at that proceeding and what they offer. One of the biggest things we run into is people think their options are more limited than they are, and that's not true. So look it up and follow, and as judges, follow the same service of process rules and alternative service of process rules that the proceeding would normally have. And from a family court lawyer and a family court judge's perspective, that doesn't sound odd at all. That's what we're always doing. But from an immigration perspective, those of you that are not always practicing in family court, it sounds a little confusing. So look at the service of process rules for the proceeding that you're in.
So Leslie and Veronica, there's a question. It says, given the most recent Board of Immigration Appeals BIA decisions, how would you recommend arguing timing to be heard in the family courts when we have a SIJS that is not aging out?
The sooner the better. I mean, you want to, I've seen many judges in the trainings that we've done through the National Judicial Network on this across the country, where people are like waiting until the child's been before the court since they were 6, and that nobody ever thought of this, and they aged out. We don't want that to happen. You need to be, as soon as you're making a placement, you want to be thinking about SIJ findings as early as possible so that child can file. If you're in a proceeding where something changes in the future and ultimately you're a judge and you're going to order that child be returned to the parent you found abused them. If you do that, by operation of law, you cancel the SIJ case. But short of that, they'll just ask the immigration lawyer later on, if you ordered it early in the case, to, with an RFE or something, to a request for further evidence to say what happened ultimately in the case, so that they can see that the early decision to place with mom, who's the non-offending parent, and the one at the end of the case were the same, which is typically what often can happen.
And us judges, if we're asked to make these determinations, need to do that as soon as possible, not postpone our decision for the best interest of the child.
We're going to turn now to thinking about what are those 3 determinations that we're asking the court. Judge Briel gave us at the beginning, right? The first is the child is dependent upon a juvenile court. And then we're going to turn to it's in their best interest not to be returned to their country of origin due to abuse, neglect, abandonment, or a similar basis under state law. And then also a jurisdiction that reunification with one or both parents is not viable. These are going to be the things. So we'll start with determination of dependency or custody. And I'll say that just to amplify the, move as fast as you can. Someone says, can we talk about the waiting times and the backlogs for SIJ in the chat? And absolutely, we'll get there. But first, let's talk about what is it we're trying to get out of this process. Let's walk through the steps, because we want to do it as fast as we can, but we're not going to cut corners and we're not going to not get the findings we need. So let's talk about the substance of it, and then we can talk strategy a little bit at the end as to how that moves through the process. So this first declaration, you are dependent upon the juvenile court. Sometimes people try to make that more complicated than it is. All it means is the court has taken jurisdiction over this child to make a decision about care and custody. That's all. It doesn't mean you've taken the child into state dependency. They've been placed in any particular place. It could be absolutely any outcome, but simply by taking jurisdiction, that child is dependent on the court. The court will decide where that child's going to go. And that's all we need for that first determination. Second one, Leslie.
So in determining, so years ago, I did trainings with USCIS on this, and I really liked the way they approached this when they were training with us back then. And they talked about basically doesn't require termination of parental rights, and that viability of reunification doesn't mean that there's no contact with the abusive parent, and that basically that you're focusing on whether or not you believe, so you're making the finding of abuse, abandonment, or neglect, or similar basis under state law. And then you're looking at, you're not trying to bid 18, 20 years of viability. You're looking at from the time the judge issued the order until the case is adjudicated, which is running about 6 months after filing. That's the period of time that you're trying to predict. So it's under a year. It's like, are you expecting that this placement is going to remain intact and this decision is going to remain the same essentially for the next year? And you want to be specific about which parent abused, abandoned, or neglected the child. And don't cite the DHS regulations. That's it. Is this still me, David? Sure, where we are here. Trying to make there we go. I think this is you.
A similar basis under state law. This comes to play into saying we don't need necessarily magic language. A judge doesn't have to say in a determination there was abuse, there was neglect, there was abandonment. Those are terms of state law. A similar basis. Some states have catch-all provisions. Ours in Michigan is a child is found in the state without proper custody or guardianship, meaning they're here, they don't have anyone caring for them, they need some intervention, and that's enough. We don't have to necessarily go out and figure out who should have had this child in care, and did they abuse the kid, did they neglect the kid, who are they? We have a legitimate basis for doing this. New York takes children into care as destitute minors, right? That is a legitimate state function, a state law function to say we're providing for the care and custody of this child. That's all we need. We don't need it to be any magic word, but we need to explain how it's based in state law, right? So, and we need to then say, well, this kid who's a destitute minor living, on the streets in New York City, why is that like abandonment? Why is that like abuse or neglect?
So David, in California, there was a case that found a parent's inability to protect was a similar basis under the law. The parent didn't abuse, didn't abandon, and didn't neglect the child. They just couldn't protect this child from gang activity, and that qualified.
So another point I want to talk about is, how do you think about the determination not to return to the home country? And this is actually the part that I did do a lot of training with USCIS on. And so you want to look at this first and foremost as a custody placement decision. You want to say, okay, who are the potential custodians that me as a judge or as a family court lawyer, my statute in the state will say who's supposed to be considered for this kind of a proceeding. So in a custody proceeding, you usually are going to look at both parents, and you're going to look at somebody else who is largely involved in caregiving of that child. And so if you have a case, for example, of, let's say, in the home country, the child was with dad and living in grandma's house, and the father sexually abused the daughter, and the grandma did nothing to stop it. And she is now before you in court with her natural mother in the United States, and you're trying to decide custody. In that case, there is the other potential custodians in this case under your state law would be, you're considering mom, dad, and grandma. You're not going to look for auntie under a rock someplace. You're looking at who was actually involved with the children. And in this case, it's going to be in the child's best interest to be placed with mom in Wisconsin or Nevada or someplace in the States where mom is living, because she's the best custodian. And that's where you want to think about first when you look at this issue about not in the child's best interest to return to the home country. If there's no best interest placement under your law there, then that's the main thing you want to find. And then you can turn to compare, to other issues about services that the child is receiving in the US, or gang violence or drugs or other things that might be happening. Anything, David or Veronica, you want to add to that? You're good?
I would just add, judges sometimes think, well, I'm not evaluating decision, I don't know much about that country or this country, or what are the conditions. And one response to that is, well, you are making a decision here today about where this kid's going to go sleep tonight. Who's going to take care of them? And in the course of doing that, you're essentially saying it's in the best interest of this child to be here tonight, to not be in this other setting. And so it's inherent. And so it may be that they're articulating that decision more precisely or in a way they wouldn't otherwise, but they're not doing anything they haven't already done as part of just their normal course of business. And so I think we can help judges have some, confidence that they're not overstepping their bounds.
I absolutely agree, David. We are making these decisions every single day.
And we have a comparison chart that I put in the chat and on the slide of best interest laws by state, if you're interested or if it's helpful. Veronica?
So we have here the best interest, the example of Michigan. And in many states, the best interest factors are not going to be found in one particular area, right? For example, in Michigan, we have the Child Custody Act factors. We have it in the Adoption Code. We have it in the Child Custody Act. So any other unique set of factors that you may have in your state, that is what the judge is going to use when the judge is going to be making the best interest determination. So it's going to be specific to your state, because remember, you are asking the judges to use state law to make these judicial determinations. Now, we are switching a little bit to talk about consent from the Department of Homeland Security. This is also something that confuses people, but it's basically once the special immigrant juvenile gets filed using Form I-360, when DHS approves it, that means the government has given consent. One of the things that we need to keep reminding people is that you need to have a primary reason to appear in state court. It's not an immigration purpose. And so that's very important, right? Like as David and Leslie and Judge Brio have been stating, if you are worried about where this child is going to spend the night, that is a legitimate state factor that you have, right? Like, why is it that you are bringing this case within the jurisdiction of the court? Remember, the judges, you're not asking the judges to make immigration decisions, right? They can't. But you are there because your primary reason is to ensure that the child is going to be safe. And so that's one of the things that USCIS is going to be looking at. Why were you bringing this case to state court? Why is it that the judge then issued the order? In many instances, we get questions when people say, well, if someone who's close to 18, why does he need a guardianship, right? He's going to age out. Like, what good is that going to be? Isn't that an immigration case? And one of these things is that you can have, as long as you have one primary purpose that is not immigration, the fact that this child may qualify for SIJ can be a purpose, right? And remember, under federal law, a child is a child up to age 21. And so with the government, the state government may end jurisdiction at age 18, but the feds continue to characterize this child as a child as long as he's under 21. So it is very important to make sure that the court orders are very specific with the findings of facts, and their orders are very specific with the service and the support that child is going to be getting, to make sure that the DHS grants that consent by approving the special immigrant juvenile. So
David,
now, David, we have an issue here. What happens if a child is in ORR custody, the Office of Refugee Resettlement? In what type of proceedings are we able to get special immigrant juvenile for this child?
If we recall, right, if a child comes in, if they are picked up by the federal government, be it at the border or in the interior, they will end up in Office of Refugee Resettlement custody. At some point, when they're detained, the government's going to look and say, what are we going to do with this kid? They are, by law, supposed to move them to the least restrictive placement that they can come up with expeditiously. We know in practice that sometimes that process lags a lot as it moves forward, but it might be that they are looking at potential sponsors. Is the child's parent out there? They can release the child from ORR custody to a parent. Can they release the child to someone who's going to be a guardian, someone who's a known person? Or if all those fail, they release them into what they refer to as long-term foster care. And that's a bit of a legacy term. We know now that, we don't think of long-term foster care as anybody's goal. We don't want children to languish in foster care, but federal long-term foster care. And at that point, the agency, the group that they've been placed with, can come into court. Now, can we get into family court while that child is being held, strictly speaking, in a detention facility at the border? No. We can't. They're in federal government custody, and at that point. But once they are released into a program, once they're placed with a program, they're in a group home. We also don't like group homes in domestic foster care as much as we tend to do that in federal custody. If they're released to sponsors, if they're moved on, at that point, we can absolutely go into court, and the state court can take jurisdiction to, in some instances, ratify this placement, right? Where the ORR has sent this. In our case, Bethany Christian Services in Grand Rapids, Michigan, gets hundreds of kids, and they go there, and then Bethany goes to court and says, hey, state court judge, we have this child now in our care, and we'd like to put this child formally into our system and move through our state law process for this to happen. So that absolutely, we can make those those determinations.
So what does the child get? So now you have gotten your judicial determination from your juvenile court. You have filed the special immigrant juvenile with USCIS, and we're going to cover this in more detail in a little bit. So that's what the child is getting, right? The system functions in a way in which not everybody is going to be getting a visa right away. Right, the only people in our complicated immigration system, the only people who usually have immediate visas available to them are the immediate relatives of US citizens. And so for a child to eventually be able to apply for lawful permanent residence to get that green card, it's going to be a time of wait. And given the big backlog that we have, it's taking many years for that child to eventually apply to become a lawful permanent resident. This is obviously a complicated process, especially if the government is also trying to deport, to remove the child from the United States. So people need to understand that this process is not automatic, right? Like someone has to keep moving this case. And we're going to show you in a little bit. If you remember the chart that David showed you at the beginning of this presentation, it's complicated. It looks complicated because it is complicated, right? And it's very hard for a child to understand where he is in that complex immigration system. Another thing too is that we need to be careful with a child who may have some issues that are going to make it harder for him to qualify to get that lawful permanent residence. Maybe he has some drug issues. Maybe he has some issues with assaulting someone or, anything related to their character, right? That is going to be a little bit harder to try to obtain for this child. In many instances, we have very generous waivers for special immigrant juveniles. And so if you are not an attorney, or if you are an attorney who doesn't practice immigration law, make sure that you reach out to us so we can guide you if your client may have some issues that are going to be problematic later on.
And when Veronica says reach out, she's talking through our technical assistance that we offer. Just a quick point I want to make here. When I first started training judges on these issues, one of the first questions I got is, this child before me wants to go home and see their grandmother who's dying and wants to come back. And can I authorize her to go? It's not about what you, the judge, can authorize them to do. It's really important to understand that any person, whether it's a child or a caregiver, who has a pending VAWA, TU, or SIJS immigration case, they should not be leaving the country. If they leave the country before they get their lawful permanent residency, before they get their U visa, or whatever the story is, it can endanger the case and they can get stuck abroad. So it's just important to understand. I just wanted to make that footnote as we go forward.
Thank you, Leslie. It's always complicated, right? Trying to explain to a child why he shouldn't be going home. But coming back to the backlog that I was talking about before, the category under the special immigrant, under which the special immigrant juvenile is the employment category, if you can believe that, right? So one of the things is that every visa category is going to be subject to country caps. And so we really don't have enough visas to process all of these children who have been applying for special immigrant juvenile. And so right now, given the backlog, right now, the government is checking, and this is the visa bulletin, this is the document that people need to be familiar with. It is issued by the Department of State, and it comes out every month. And it's going to tell you, are you ready to be able to file for that green card for the kid? And if you see the fourth category, it is checking applications of people who submitted a special immigrant juvenile back on October 15, 2022. What does that mean? That means that only people who have earlier than this date applications are able to apply for lawful permanent residence. So if you are filing for a child today, that child is going to have at least 4 years of wait before he's able to apply for that green card.
Just to emphasize that point, people were asking earlier, when's the time to start this process? When do we want to do it? It's now. It's fast, because that filing of so once you've got your state court findings, your determinations, and you file with USCIS, that's where you get that date that Veronica has highlighted in yellow there. So that's the step that locks in the date and says you're in line, you're in the queue. And until that happens, you're not in the queue, and it doesn't matter when you started the process. You're just time's flying by.
So given this backlog and the inability of people to obtain their green card, we were issued deferred action under the Biden administration. A lot of advocacy went around this, asking the government to issue deferred action for children who were pending, who could not apply for their green card. And so deferred action, the idea was, okay, we are going to defer any action on these children, and on top of it, we're going to allow them to apply to get a work permit. And so the children, now adolescents and even adults, didn't mind if they weren't able to apply for the green card because they were able to work, right? And once you have your work permit, you are able to get a social security card, you are able to apply for a driver license, you are able to get your state issued ID. And so those things were amazing for these kids who had been waiting for a long time. In June of last year, this policy was rescinded and the children no longer qualify for deferred action. And so that has actually decimated the opportunity for children to be able to have their work permit. And so they are, because we don't have deferred action anymore, they are getting their cases approved, but they are not qualifying for deferred action. So no longer able to obtain a work permit. In addition, as of last year, we also got a fee imposed on the special immigrant juveniles. Now people have to pay $250 to apply for special immigrant juvenile children who have no ability to work are being asked to pay this $250. It's not, you don't qualify for a waiver to be able to do this. And so
So, Brio, what options do judges have or child welfare agencies have? Is there something courts could do to help with the fee?
Well, a judge can certainly appoint an immigration attorney for the child, because as we've been hearing, we judges are not immigration attorneys. We don't know immigration law. We only know custody law, abuse, abandonment, neglect law. We can see if an immigration attorney has an idea. There's some discretionary funds with Child Protective Services that I would insist that the Child Protective Services social worker use for this money. If they can pay for a child's braces, no matter what their immigration status, I think they can also pay for the fee. But there are certain nonprofits that we might get the money from, and I think it requires brainstorming, free thinking with the judge, the social worker, the attorney, the advocate, the entire team.
And what I found is if you're talking though about SIJ cases in contested custody proceedings, divorce proceedings, protection order proceedings where the abuse is happening in your community, the abuser can be ordered through court order in a family court case to pay the fee. So Veronica, I wanted to ask you, so we're going to talk about a couple of questions here. Can SIJS judicial determinations be done in federal court?
no,
Okay.
it's only state court, right? It's juvenile court. So the feds don't have jurisdiction to issue this. They are in deciding custody and care of a child.
And for SIJS judicial determinations, does custody refer to physical or legal custody or both?
It could be either or it could be both, right? If the judge is determining where that child is going to spend the night, then we're focusing on physical custody in these cases.
Okay. Could SIJS be ordered after a termination of parental rights or where during the pending of a parent's appeal?
Yes, and we did cover this earlier, right? But remember, you do not need to initiate termination of parental rights to get this issued.
Right. And let me just answer the last one. basically just a word of warning, like if a judge issues an order returning the child to the parent who committed the abuse, abandonment, or neglect, that by operation of law negates the SIJS case.
To broaden that out, someone asked in the chat whether SIJ can be rescinded. So while it's pending, if your, SIJ petition, if it's granted, could be rescinded if certain facts change, like that, returning the child to the parent who was found to have been abused. Once a child gets through the process and has their green card, they've adjusted and become a lawful permanent resident, then we're not going to go back and look and say, oh, but now the child's living with mom or dad or whoever was at stake there.
So
But
I'm
often
gonna
there are times when a parent's attorney will say, my client is rehabilitated. They've done what they need to do. They are now drug-free. They've taken classes on abuse of children. So now you should return. I mean, we do see motions like that in state court all the time, and this can negate the special immigrant juvenile pending case.
So judges should be aware of that. It's really important.
Yes.
So Veronica, what if a child, we're going to do a couple of hypotheticals now to kind of help people see what this looks like. So what if a child, let's say from Venezuela, is in foster care in the US, mom is in Venezuela and child welfare, CPS, is in contact with mom. The father who abused the child in Venezuela can't be located. Does the child qualify for SIJS?
Yes.
Based on what?
Based on CPS involvement, CPS is able to bring that petition before the judge to ask for the judicial determination. So you have abuse and abandonment by dad, right? And so that's enough. That is enough for you to proceed with a case like this.
And can mom apply for or benefit from the SIJ that the child files?
Parents do not benefit from any benefit the child gets under special immigrant juvenile status. And there is a recent case of someone who became a US citizen eventually, but who had an underlying special immigrant juvenile case and applied for the non-abusive parent. And the court said, no, the law does not allow for parents to obtain any benefit, even if they are not the parent who has abused the child.
So let's do another scenario. Mom is living in Wisconsin with 2 children. CPS has placed the case with mom through an informal consent agreement. Mom is a crime victim with a pending U visa case that includes her children. Dad has had no contact with the children and cannot be located by CPS. Could the child qualify for SIJ? And in what types of cases?
Yes, again, it's the very similar fact pattern, right? Like with CPS is one of the agencies that is able to ask the court for the judicial determinations.
Right. Okay, great. Okay, so now we're
All
going
right,
to
so let's look at another poll. What other forms of immigration relief might a child who is SIJS eligible also qualify for? T visa, U visa, VAWA self-petition, asylum, family-based visas. We should have maybe said all of the above, none of the above.
Okay. We're going to give you another few seconds. Watching the clock here. Okay. So it looks like 82% of you said T visas, 86% said U visas, 69% said VAWA self-petition, 80% said asylum, and 66% said family-based visas. It could be any of these. The ones that are most likely to be most fruitful. So you have a child that qualifies for SIJ, and you're looking at what else they might qualify for. They might have an asylum case because they were picked up and they're in immigration proceedings. They might have a family member who could sponsor them, in which case there could be a family-based visa application. But what you should be screening for most commonly are the T visa, the U visa, and VAWA. There we go. And so just for those of you, just a quick review, U visas are for criminal activities committed in the United States. Unfortunately, often the youth in court before you in these family court cases may have also experienced, because they're very vulnerable to experiencing crime victimization in the United States. So you may have that, you may have a U visa. You also have children that may be sex or labor trafficked in the United States. And if that occurs, they could qualify for a T visa. If there's battering or extreme cruelty committed by a parent or step-parent who's a U.S. citizen or lawful permanent resident, and we see a lot of step-parent cases, for example, under immigration law, step-parents are the same as parents, which is very different than our state family laws. And so they could potentially qualify for a VAWA self-petition. And so what we're recommending is that you continually screen for victimization when you're working with immigrant youth, even if they qualify for SIJ, because of the things Veronica was talking about in terms of having to wait a number of years before they can apply for lawful permanent residency. And when Judge Breel was talking about where you might find an immigration attorney that has expertise on these VAWA T, U visa, SIJ cases, we have a directory of programs that you can use to look that up in your community. So how could filing another type of immigration case help an SIJS child? And because of the time, I'm not going to have you type in the chat. I'm going to kind of walk you through the answers. Tried to change the slide and it didn't go. There we go. So this is a chart for you. This is a lot of detail. But the big points I want to highlight are that SIJ children who are victims of crime in the United States, if they file a U visa, will have a path to work authorization and deferred action 1.6 years after they file their U visa case. That's what they're currently running. So if they also experienced crime victimization or child abuse in the United States, they could file a SIJ, which will get them to a green card faster than the U visa, but the U visa will give them access to work authorization faster. And if their abuser is in the United States, it will give them a special VAWA confidentiality protection against deportation. So it's not going to be uncommon to see children have to file multiple types of these immigration cases to promote their best interests and stability as they navigate their way through the SIJ process. And from a public benefits perspective, you'll also see, I'm using Nevada as an example, there are dramatic differences between SIJ and T visas and U visas, or T visas and VAWAs. VAWA self-petition and T visa children have better access in many jurisdictions to a lot of different kinds of benefits that compared to SIJ, particularly when it comes to housing, TANF, and SSI, if those are the issues of the child's needs. In terms of the federal public benefits, you can see that in many states, Nevada being an example, the wait to public benefits and publicly funded state and federal public benefits is much longer for adults than for children. So intervening early is super important. So as to the public benefits, we have materials that you can walk you through how you can look up if a child needs public benefits or services in your state, what they qualify for on SIJ, what they qualify for if they additionally file a T visa or a U visa. And these are the various, we have this shield for you. This is written by the Department of Homeland Security. And it's particularly important because it shows you that the Congress created a shield, let's say, of different kinds of benefits, immigration relief for victims of crime and abuse, including many of the SIJ children that you're seeing. And that anytime you're working with a child or a caregiver or a guardian who may qualify who may have suffered one of these forms of crime victimization, they will be eligible for one of the forms of immigration relief tied to crime victimization in the United States, T visa, U visa, SIJ, or VAWA, that may not have been recognized. And so, and these relief, when we talk about VAWAs, Ts, and U visas, it helps both documented and undocumented immigrants. And you should be screening not only the child, but any potential caregivers, because you may find that those caregivers actually qualify for immigration relief and don't know it. And so it's really important to do that as well. So in this scenario, we have, so in a child welfare, there's a child welfare case filed, and there's a finding of abuse by mom. And the question is then the child is placed with their undocumented aunt, and mom is threatening to call ICE on the aunt, threatening to have aunt deported as in retaliation for getting involved and taking custody of the child. What protections might the aunt have? It could be, if we look at aunt and see whether she's married, you might find aunt is married to a U.S. citizen or a lawful permanent resident. And if she's a victim of domestic violence, the aunt might qualify for a VAWA self-petition or a battered spouse waiver. Additionally, it's possible the aunt should be screened for human trafficking. The aunt may have suffered sex or labor trafficking at work. Maybe she was a victim of labor trafficking and qualifies for a T visa. And if so, she'd have a path to more stability that includes VAWA self-petitions and T visas, as well as U visas, which we're going to talk about in a second, include special victim protections from deportation that SIJ children, for example, wouldn't otherwise have.
So U and T visa certification requests are requests that judges can sign and should be signing along with the judicial determinations for special immigrant juvenile status when presented to them. There are toolkits, and you can go on these links. NCJ, FCJ, and NEWAP have all sorts of information. The U visa requirements, you have to have a victim of certain qualifying crimes, and there's a whole bunch of them. We're going to show a slide in a second, and they have to possess information and either have been helpful, are being helpful, or will be helpful in the detection, investigation, or prosecution, conviction, or sentencing of a case. And they have to show, there has to be shown substantial harm. But as judges who sign the U visa certification form, we do not have to make substantial harm showings. For law enforcement, it can be any of these agencies. It can be prosecutors, judges, social workers, magistrates, Department of Labor, the whole list here, sheriffs, FBI, other government agencies with investigative authority. These are all the folks that can sign U and T visas certification requests. Okay, so we're on a poll.
Well, and I just want to say that judges will need to amend the form when they sign the certifications, and that there's a difference ethically in terms of judicial ethics between open and closed cases. Generally speaking, judges will see certification requests in closed cases after a judge in their court has ruled. Is that your experience?
There's no statute of limitations as to when a judge can sign a U visa certification request. It could be 10 years after a domestic violence case, and you don't have to have a police report. You don't have to actually have a conviction or a prosecution for a judge to sign. A judge is not an investigator, so when the judge signs the form, if they don't like that word investigate, they can cross out the word investigate and go ahead and sign the U visa certification request.
So now we'll do the poll. Sorry about that, NCJ, FCJ. Am I too late? There we go. Okay. So why might a victim come to a judge for certification as opposed to law enforcement, prosecution, etc., prosecutors, etc.?
So it's the only justice system contact. There's no language access when the police came. The police did not investigate the case, never sent it to the prosecutor, the DA, and the judge observed the victim's attendance and participation in the criminal case, but they never sought the certification before that.
All right, so those are the options. We're going to end the poll, share the results. So have you seen these, Judge Briel, as
I have
as
seen
reasons?
all of these. I would say all of the above. I'd even include housing court, where I once saw a case of my colleagues where the victim was being evicted, and she said she was being evicted because the landlord raped her. And all of a sudden, there's criminal activity that qualifies, and a U visa presented to that judge, and he signed the certification request. So it can be all of the above. Often you don't see a prosecution. Often you don't see a case. Often the police officer doesn't refer it to the DA, or the DA doesn't file, but you can still issue a U visa certification.
So it can be a judicial certification can occur in a purely civil case, and it doesn't have to anticipate that there will ever be, or ever has been in the past, a criminal case.
Correct.
And so, yeah. Judge Briel?
So helpfulness, what is that? Helpfulness is either has been, is being, or likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of a case. You can give a victim witness statement, never having come to court before, and be helpful. And here are all the places, all of the forums where helpfulness could be detected by a judge. Termination of parental rights, civil cases, employment cases where there's abuse of an employee, tort damages against a perpetrator, divorce, restraining order court where there was never any case before someone applies for a protective order from their abuser. Helpfulness includes all of this: 911 calls, allowing for photographs and never coming to court after that, filing for a protective order, as I said, providing evidence of abuse to a judge in a dependency case or a delinquency case, bringing a minor victim to court, or a child advocacy center can be helpful. And again, when a judge signs the certification form, since we don't investigate, and it says here based upon investigation in the form, you can cross that out if you're a judge and you are not comfortable with that language. But you can amend the findings and sign the case. And again, I signed many of these cases.
For the lawyers on the call and the advocates, if the judge ethically needs to cross out the last line because they can't promise to follow that client in any way in the future, because that is a violation of judicial ethics. So if they make these changes to the form, don't panic. USCIS accepts these judicial certifications like this all the time.
Right. I'm not going to follow the case, and I'm not an
Yeah.
advocate. I'm just a judge.
So we are now, any last words, David and Veronica, while we're pulling up the evaluation and the resource material slide from you all?
I wanted to make sure we answered the question on if the victim statement exonerates a defendant. Is that helpful? So, Judge, I don't know if you want to answer. I was typing an answer.
Well, if the
I don't know what's
victims,
going on. Is this
if they're helpful and they've still been a victim of a crime in some way, and you look at the totality of the circumstances and there's evidence of some kind of abuse, I think they have been helpful.
Right.
So I
And
guess
also-
And remember,
it
you
depends
don't
what
need a conviction, right?
That's
Like
right.
you
That's
are
right.
being helpful in the investigation or prosecution. You don't need a conviction.
correct.
Right,
Yeah.
and maybe they,